Yes.
For delivery of orders item number 1, WPC 5919 of 2025.
What mentioning?
May I have your lordship?
Mentioning, let it be allowed, we deliver a judgment later.
Sorry, mention please.
Why at the back end of the vacation, why you are? Now only 3 days are left.
Your lordship, the content matter is very urgent because of your lordship, the on this one call is directed, order dated 5/10/2023, your lordship. And the
23 order.
These are rehabilitation amendment rules in the year 2020.
You give, we don't know whether we will be able to do it or not. Give, pass on the memos.
Day after tomorrow.
Sir, pass on the memos. We don't know what we'll do.
By not have you permitted item 60.
Like again.
Start 60. I think I meant after vacation, 18th or 19th. Because
Any person who is appearing other side,
no, that they have not appeared. I used to do this.
so just remind us if we reach item number 60, send any junior just to remind us. No difficulty.
Item 67. 67, 13.
If it reaches, then if it does not reach, it will go automatically. Don't.
It's item 67. Pertains to acceptance of requisites. That compensation matter which your lordship said we should notice with regards to inclusion.
Let us see. Let us see. Let us see.
Item number 62, because it relates to a PIL, mining operation over the forest area.
Let
Not
us-
likely to be reached. So
Let us see. Let us see. Let us see. Yes.
May I have your lordship's kind leave to mention a matter virtually, your lordship? Your lordship, this is with regard to item 20 of yesterday's EXFA 1 of 2025. Your lordship, the learned AG, I have been told the learned AG yesterday morning mentioned that he was unavailable. Your lordship, I just pray for some indulgence and precedence in this matter, your lordship.
Let us see. Let us see, sir. Let it be called if we reach. Yes. Can we do it at 2 p.m. Delivery of judgment? Just to go through that judgment which you. Huh? Oh, yes. The dictation. Judgment.
Item number 1, WPC 5919 2025.
Judgment.
2733 of 2024.
The second direction is the appeal is allowed, and all pending uncertainty applications shall also stand disclosed. As a consequence, the restriction also stands allowed. In the circumstances, there shall be no other action process.
Item number 3.
Oh, that I want to dictate. Yes. Come at 2 p.m. I will dictate. Up.
Item number 4.
Yeah.
this reduction has been preferred as the order part is going to change as
Any delay?
Sir, ma'am.
Any delay?
Condoled.
Okay.
My lord, going to the impugned order, may if an office may place a little bit of fact.
Yes.
Initially in the year 2003, there was a recruitment for the purpose of
Mr. Rath, you want to file any response to this writ appeal?
Not necessary.
Not necessary.
Not required. Only one point of consideration.
yes, I'll confirm that. I'll not take much time of the lordships. Act is my lord, in the year 2003, there was a recruitment for the purpose of appointment of Swachhasevi Shiksha Sahayak. Petitioner was found successful and placed at serial number 18. In the year 2006, my lord, he was disengaged basing on a direction issued by
It was under a project,
Yes.
under any specific
Scheme.
project, scheme or project, whatever.
Yeah, his king.
Yes.
He was disengaged basing on a direction issued by this honorable court in all the writs.
Okay.
That disengagement order was challenged by him before this honorable court. This honorable court directed for consideration of his case once again. If it is found that his case is not covered by that judgment rendered in another case, then he should be re-engaged. That was the direction issued. Thereafter, the collector passed an order rejecting his case. Again, he came before the lordship another petition with a prayer for regularization of that period. 2003 he was engaged.
Disengaged in
2006.
3 years.
No, sorry, my lord, 2009.
6 years.
He requires regularization from 2006 to 2009 because 2003 he got appointment, 2006 disengaged, 2009 once again appointed. So 2006 to 2009 he wants regularization, and thereafter on a subsequent stage when he was put to notice as to why his services shall not be terminated, again he came before the lordship. That was allowed. Against it, that we have come up in this writ appeal. Only I'll take your lordship to 2-3 documents only. Page 68 of the impugned order. Order passed by the Honorable Single Judge, which is available in internal page 11.
Yes.
You have also got it B. Submission on behalf of the appeal party state. Our submission, that is B, out of 132 posts, 70% posts, that is 9 posts were allotted to city candidates, and 30%, that is 40 posts were filled up by candidates in B. Out of the 92 vacancies for city candidates, 15 vacancies were reserved for SC category. We are concerned with this one. Thereafter, my lord, last line, accordingly, merit list was prepared in which the petitioner secured 18th position after scoring so and so marks. Therefore, the petitioner was placed at serial number 3 in the waiting list. 15 posts were available, he is at 18, that is why waiting list 3. Now, your lordship kindly come to D, next page 69. The petitioner was given engagement as such as the Shiksha Sahayak pursuant to the said letter dated so and so of the School and Master Education Department. However, the said letter dated 26/9/2003 was challenged in the case of Ruchikesh Nari and others versus State of Orissa. This court by order dated quashed the above letter dated 26/9/2003 and held inter that any appointment pursuant to the said letter dated 26/9/2003 is void. And all such appointees appointed pursuant to that letter are at liberty to participate in the election process. That is how his services were terminated. Now, skipping many things, I'll pray your lordship to come to 141.
141. Find out.
Just to show to your lordship that he is placed at serial number 18.
Oh, no difficulty.
Not that much.
Correct.
Now, your lordship may kindly come to the prayer made in the writ petition. As I was submitting, my lord, his prayer was He was challenging disengagement order, so also regularization for the period from 2006 to 2009. We are not against him as against the prayer to pass the disengagement order.
You wanted to engage. You wanted to engage.
He can be engaged.
Uh-huh.
What I found from the documents, it will not be proper on our part to say that he should not be engaged.
Correct.
But he cannot get the benefit of 2006 to 2009 because
She was not engaged at that point of time.
that
And her
point of time,
termination was
admitted
there.
she was not there.
And by virtue of a fresh engagement,
Yes.
she was there in
That he
2000.
accepted also. Press engagement. That document is available in the read petition.
Which one?
Yes, my lord, I'm pleased.
Annexure?
That is at page 20. This is at page, when internal page 25 of the read petition. 24, sorry, ma'am. 24.
Yes.
As per direction of the Honorable High Court and disposal of so and so, collector report, Sri Devendranath Malik, क्या है? Category of Rajnikant block hereby engaged.
The date of engagement will reckon from the date of his joining.
Yes, ma'am. This has not been assessed at any point of time. He has accepted it. So, if you're in the read petition, if your lordship comes to the prayer is available at page 17. Your lordship, but under the above circumstances, it is there.
Reinstate the petitioner in service and grant him all consequential. So joining is not an issue. That he should be reinstated is not an issue.
Not an issue, but
Only thing is consequential service and financial benefit. Treating his initial date of joining as 2003.
We are against that.
And this order, the order of declaring that particular appointment as void,
Yes, ma'am.
that has not been assailed anywhere.
No, it was assailed in this read petition.
No, earlier order.
That has not been assailed.
Page 7, madam. Page 7 of the petition.
No, was it assailed before the higher forum and the order was set aside because the single bench held that this appointment which was done in 2003, though those were found to be illegal and void, and therefore directed the engagement to be cancelled. Is it?
No.
Then?
Rather, this honorable
And then say that they may participate afresh
yes.
in the subsequent advertisement. This is what I was coming.
That is that.
So that engagement was declared to be void. That means of no consequences.
On 9 only, it can be taken into consideration. But
That was
but in the impugned order, the honorable single judge has directed to the benefits
declared as a
having come to
void, then
country.
void for all time to come. Onwards. Now tell us, sir.
2000 advertisement.
Correct. And that engagement was declared by the court to be void.
I challenge that.
Once it is void,
Right.
did you challenge it in the appellate forum?
I challenge that order by filing writ application, page 7.
Can you do it? Because that was a decision taken by the writ court.
Yes.
But I am submitting my.
Can a writ petition challenging the order passed by another coordinate bench? What? On the ground of nullity, except otherwise not?
I'm just submitting the 2 minutes facts, man. And advertisement was published in 2003. I applied in pursuant to that advertisement. A merit list was prepared. An engagement order was issued in 2003. I was allowed to continue in 2006. I was disengaged on the basis of an order passed by this honorable court in a different case. In a different case, I challenge the disengagement order with a prayer that judgment is not applicable to my case because there is a condition by this honorable court. If some appointment was made in pursuance to without any advertisement, that appointment had to be declared illegal appointment. Since I was within the merit list and I was appointed within that advertisement was never passed. I filed this application with a prayer that judgment is not applicable. Page 7, my lord, I see. Page 7, the order.
No, where is the order of the single bench where it was declared that all appointments pursuant to this is void?
My.
Where is that order?
Yes.
And can you see
of the single bench
page 157,
of the
each appeal.
writ appeal.
Operating part, madam, last paragraph, can you see?
The operating portion starts from 157 last line.
Last paragraph.
157 last line. The opposite parties are next page.
Oh my God.
Directed to make a fresh advertisement for recruitment of
So
15,618.
Rotate.
Thanks.
Last 4 lines, 5 lines. On perusal of the so-called replies filed with the Commission on Secretary School and Master Part of the College of I do not find any.
can you give me a file?
Procedure in the office.
I'm unable to figure it out. There is scanned in a, sometimes it is an inverted page, sometimes
Clockwise, anti-clockwise.
so clockwise, anti-clockwise.
In terms of this direction only, he applied for first.
No.
সিঙ্গেল করতে আমি করবি এটা হবে পছন্দ করতে হবে নেক্সট পেজ বেশি মেন পোস্টার এই
Where it is declared as what?
এক্সেল এই ওয়ান
Madam, para 5, madam. Para 5.
It is available at page 158. Challenge of the petitioner to cross-check for heat of the manual on the ground of party.
No, I am unable to comprehend that where it is said. Where it is said.
Directly, it has not been written, but it has been written that accordingly, the prayer of the petitioner on this score is rejected.
No, he was not a party there. He was not a party in that petition.
In this
But I just wanted to know, was it a judgment in rem or a judgment in personnel?
it is a judgment in.
This is what I wanted to find out. Tell me that it is a judgment in rem, where it says that the entire selection process which was undertaken was absolutely contrary to the rules.
Yes, no, your lordship.
Where do I find it?
Your lordship will find the circular dated 26/9/2003.
Because this is in such a way I can't read.
I'm sorry, but now. Can it come tomorrow? I'll try to.
No, just show me. I just try to understand.
156. Take up my copy. It is little bit visible.
No, it is also legible. Just show me.
156 page paragraph.
Yes, according to the petitioner.
Leaving 3-4 lines. On 26/9/2003, it is in the middle portion.
Yes.
On 26/9/2003, the Commissioner cum Secretary to Government of Odisha issued a circular where he directed all the collectors of the districts to recruit further 15,682 numbers of Swachhasevi Shiksha in the state immediately. The Commissioner further advised that the list of eligible candidates out of the pending applications should be kept ready so that instead of going for fresh advertisement for Swachhasevi Shiksha as per the need, recruitment can be made from the same throughout the year.
Yes.
Thereafter, para 4, we can skip, my lord. Para 5. On behalf of the state, a counter affidavit has been filed sworn
By the Joint Secretary to the Government of Odisha.
Enforcement Department, wherein it is stated in paragraph 4 that regarding recruitment of 15,618
Now,
members of
first query is whether he comes within that 15,682.
he comes means these are the posts required.
There are total posts of 15,682. Does he come within that purview of 15,682?
Because the earlier recruitment, his position was at serial number 18. He was in the waiting list third position in the waiting list. So naturally, while filling up the rest post available in the state,
Yes.
candidate nature has to be considered there.
So this he comes within 15,682. Yes, then proceed.
Then, my lord,
The state government has not asked for fresh advertisements
yes, my lord.
because the select list has the lifespan of 1 year.
1 year. That is the crux of the point. Lifespan of 1 year. After expiry of 1 year, he cannot be considered in that select list. He has to be considered in the second select list, second recruitment process. Therefore, the instructions issued to the collector by the Secretary to Government School and Mass Education Department under Annexure 5 is contrary to paragraph 5.4 of the guideline issued by the government. Accordingly, Annexure 5 is set aside. The opposite parties are
Guidelines is set aside.
set aside. That is 26(9), my lord.
Correct.
That is set aside.
Correct.
The opposite parties are directed to make a fresh advertisement for recruitment of further 15,682 number of posts of social service attached. The petitioners are liberty to apply for this.
Now, that is what I am asking, that whether this recruitment drive which was done in respect of 15,682, he has been appointed there, he was appointed or he was not appointed within that post?
Our stand is he was appointed. He claims that he has not applied for.
He does not come within that
Our stand
15,682.
is he comes within that
Correct.
15,682.
Their stand is,
He states that I never applied for that.
then how he was engaged?
Because he applied for the first process of recruitment. He was in the waiting list. He was taken into consideration. That is how he was appointed.
Okay.
And that about there was a direction from this honorable court to consider his case. So considering his case, he was given appointment in 2009.
It was found eligible in the earlier one. That's why we-
So Das, please make a clarification.
Which one?
Sir, this particular writ petition, which is disposed of on 29th of April 2004, or what?
2004, madam.
2004.
First,
Please tell me, this relates to which recruitment drive?
May be subject to my.
Because there appears to be a confusion in my mind. I tell you very frankly, how the things have moved, I do not know, and how the orders are passed, I do not know. You said that he was already there in the select list,
yes,
waiting list,
2003. Process of
2000. Now this 2003 recruitment drive or engagement drive that was initiated on the basis of an guidelines
advertisement.
advertisement. What was the advertisement?
To fill up post of seat.
What was, I mean, when I have to fill up the post for the first time?
First one.
First time. Now, this advertisement is found to be contrary to the guidelines, or what? Yes.
Well, that is that.
How this 15,682 figure was arrived? I still very clumsy, the entire order.
Page 189.
Bring it to your notice, 160.
160.
So, another report.
Right by whom?
Sole proprietor. Report that excess of the that is one. Single judge interview. Yep. Advertisement agency with legal you also get both fill up for them. Anticipatory.
No, this is no opinion is expressed on that. No opinion is expressed. I just wanted to know whether
References to
29.4, that is an order. No, what was 29.4 order? I am unable to get it from that order, that what was the subject matter of challenge.
Page 189. My lord, get 189.
156 per second.
So may I take it, if I correctly understood this, there was already an engagement as a non-formal teachers having a CT training certificates till 2001.
Yes.
Then that scheme was abolished. Then the government decided to frame another scheme of
Swechhasevi Shiksha
Swechhasevi Shiksha Sahaya. And this scheme was published on 25/3/2003.
Yes.
And the applications were called for. And it appears that as per the resolution of 1999, when that earlier scheme of non-formal teaching, the list which was prepared, second list, select list, was directed to be considered under this scheme.
Correct.
Am I correct?
Yes.
Under this scheme. And then the commissioner directed that all those pending applications or whatever is there in that should be made ready so that you continue.
Continue.
Then this particular decision of the commissioner was challenged.
Yes.
And by this order, the court has held that this particular direction of the commissioner is void.
Yes. That will be 11,748 of two.
Is void. Now, once it is void, then those engagements which was done on the basis of the earlier scheme, which got abolished, or an engagement which was done on the basis of the commissioner's direction, those were affected by this judgment.
Yes.
Correct?
Yes.
And then, on the basis of this judgment, all these engagements were cancelled. Then he challenged this. Let me understand. Please, let me understand. Then he challenged this. He says that I do not come under the purview of, he wanted to say, under the purview of this commissioner's order.
That is his.
That means then what was his contention? Where he was continuing? Then, sir, question is, if you were continuing as a non-formal teacher since earlier, then what is your right? Because that scheme got abolished subsequently. If you say that you were engaged in 2003, that commissioner's order, then once the court has declared that particular commissioner's order to be void, kindly visualize, void for all times to come, then in that event, what right you have to get engaged under that particular order of the commissioner?
I was not engaged as a non-formal facilitator. I was engaged as a Swechasevi Shiksha Sahayak
That is only in terms of 2001 scheme.
in 2003 advertisement. 2003 scheme.
One scheme and 2003 advertisement.
My lord, 2000
That is the commissioner's order.
No, my lord. Before that, my lord. That is the point, my lord. My only point, my lord. 2003, March 2003 advertisement was published and July 2003 merit list was published. Director passed an order in September 2003. So September 2003 for, my lord, that is the date. That is
No,
the
no.
date.
What was declared to be void?
15,000 some more posts.
No. What
My-
is declared? The court has said that this cannot be done
That is
because the lifespan of that particular
1 year.
the select list expires 1 year.
My merit list was prepared
So-
on July 2003, my lord. I was engaged in November 2003.
Correct. I am just talking about that this November 2003 when you are engaged
My lord.
under what order? The order of the commissioner?
That is, they are saying that since that is the point, my lord, for consideration.
Correct.
That I was engaged in pursuance to the, if I was engaged in pursuance to the commissioner order, definitely my appointment would become illegal, my lord. My submission to March 2003 when advertisement was published, July 2003 a merit list was published and I was within that merit list. If engagement order was issued November 2003, even if by September 2003 commissioner passed any order, I was within the 8,000 post which was initially advertisement. The excess post of 15,000 which was commissioner subsequently passed, that without advertisement you go on for appointing them, that was declared by this honorable court to quash because with that is the page 189 my lord got it.
Then how you got within 8,000 because you were not in the list of the selected appointees?
Man, that is,
You were in the waiting list.
man, that
Then
is,
how you were appointed?
I was within
If
the
the entire list is exhausted
Man,
with the select list, then waiting list candidate, what right he has?
my position is the serial number 18.
18 means
18.
you are in a third waiting list.
Serial number 1, 2, 13, 14, they did not join. That is my stand before the honorable civil judge. Serial number 1, 2, 13 and 14, they did not join in the inspection draft. They did not join. So I am coming within that 15 post my lord for SC. 15 post and
So
reserve.
2 persons above you, what they did?
The 2%, 1, 2, they also did not join. That is their affidavit. They joined in 2011 in subsequent advertisement. That is the affidavit filed by state government. Waiting list 1 and waiting list 2, they also did not join. So I am coming within that 15 post of 2003 advertisement. And September 2003, commissioner passed an order in persons that they issue engagement order to different persons. They were disengaged.
Well, then he's correct. Then he is correct. Because I find your work. He's engaged.
So after this successful, after I think 4 years of whatever time limit is there, they to junior teachers.
Treated to be.
Junior teachers.
Okay.
Swachhasevi Shiksha
They after 3 years they will take a junior
3
teacher.
years.
There after 3 years they will take a regular private school teacher. So at Shiksha
Junior teachers, they were made to after 3 years
junior
of joining of this Shiksha Sahay, Swachhasevi Shiksha Sahay,
junior teacher.
that junior teachers.
Right.
After that,
Thereafter another 3 years they will be regular private school teacher.
regular primary.
Right.
That is it.
The questions are
That resolution.
that is
By virtue of some resolution.
resolution of dated 10th of February.
That we want to hear. We can't throw it out as it is because
That
these
is-
facts have the facts to be brought. It is not sad. This is a most
That's
difficult
the-
one.
That's why I asked
And-
you to file response so that we get the continuity of
The
fact.
facts are so distorted from both ends. It's very difficult to find out. We have to just go through the documents. What we gathered is what your contention is that there was a 25th March 2003, there was an advertisement which was published in terms of 2001, this particular scheme. There was a select list which was prepared. Pending the select list, then in the month of June 2003, the commissioner issued a circular saying the further 15,000 something post is to be filled up from the select list, which is already there. And then he continued with this, and that was challenged. So according to you, this circular, this commissioner's order of June 20, 2003, June it was.
26/9.
I do not know, September, that is under challenge.
No.
But the select list prepared on the basis of a March 2003, that remained. And that was in respect of 8,000 candidates. You'll have to show from the documents, otherwise it cannot be done. File your counter.
This continuity we require to have that change to companies.
I didn't know that because I have come from a place where Sarva Siksha Mission was the motto, where these engagements of the Sahayak, Siksha Sahayaks were there.
It is
But they
also-
were not given any perennial or permanent status as of now. They remained under the project, they remained engaged, but no right as a direct teacher or an assistant teacher or a primary teacher.
Here, my lord,
So I have to see. If you say the government has taken a decision, we'll have to see that. Yes. Counter by 1 week after the vacation. Matter to appear thereafter.
Item number 5.
Next day, you also can take an after vacation, Mr. Disproportionate.
Yes, after vacation.
Obliged.
Item number 6.
In Bengal, actually, Sarva Shiksha Abhiyan. Yes, sir.
May I please? Well, this return arises out of an order of order in dismissal. Dismissal in a disciplinary proceeding in respect of an officer of the bank. The order was challenged in the and was confirmed by the appellate authority. Thereafter, he filed a writ application challenging the same. Honorable single judge was pleased to set aside the order of dismissal, but since he has already retired,
On what ground?
so on 3 counts, that there is a bias on the part of the inquiring officer. 2, there is a violation of principle of natural
Justice,
by
yes.
withholding 3 documents. 3, that the conclusion arrived by the inquiry officer and the disciplinary authority is erroneous on the premises of the finding.
Perverse.
Yes.
So these 2 counts are very important. One is the violation of principle of natural justice,
Case
is a very important facets of the disciplinary proceedings,
our
and
case,
the perversity is also one of the ground.
our case is that bias has been alluded.
Bias, forget about it. These are more subjective satisfaction.
The principle of natural justice is violated.
If they ask for 3 documents, why you did not supply them 3 documents?
What are the 3 documents I am telling you? 3 document has no relevancy so far as the case in question
Maybe
is
you may
concerned.
think it is not relevant, but that may be relevant for a purpose of a defense.
Contents of 3 documents will not, if no prejudice is caused to the inquiry. That is our case.
So there are two aspects.
Yes.
One is the document which you think as a prosecuting authority that those are not relevant. But those documents may be, because those are there on record, maybe for the purpose of their defense. They can take a defense on the basis of those documents. If you do not supply, then what will happen?
Your Lordship sees, if they correlate to the anyway in the charge, we are bound, not otherwise it will be perverse.
There are a decision of that the authorities
Well, that
may not consider, but that once there is a document which is reflected, you may not consider or you may not take into account at the time of the prosecution. Or
Maybe case also
Supreme Court has said that for the purpose of defense, they may.
I've seen it.
Yes, for the purpose of defense, they can.
may I place for there are 2 charges. One charge was that you have opened up an account in pursuance of a sanction letter by a person who is not authorized to sanction the loan amount. Then the second charge is that the accounts could be only be opened by a password which is exclusively yours. The he asked for audit closure report to show that the bank's loan was subsequently recovered, there was no pecuniary loss. So we say that whether there was a pecuniary loss or not subsequently is not material. It is a question of whether you have discharged your.
Have you seen the recent judgment of the Supreme Court on that? Based upon the old judgment, there is a distinction one may draw. If disciplinary proceeding is initiated on the basis of the imputation of the charges with the relevant statement of facts.
Yes.
You may include certain documents which you found in course of your preliminary inquiry.
Right.
And then the inquiry officers, he invite them to come give, and you may also include those documents are there. Now, you may consider certain documents irrelevant for the purpose of a charges. But if the delinquent found that certain documents may throw by and is very much necessary for the foundation of their defense, will you not supply those documents? Is it not a violation of principle of natural justice? So that is what they say. They wanted to take a defense.
Whether it is
That may appeal to the inquiry officer or a disciplinary authority is one thing. It may not appeal to him.
right.
But there must be a decision in that regard that why it does not appeal to me. But can you shut down a defense which is available to him?
Whether those three documents are the basis of the foundation of the charge.
That is what he can take a defense. That yes, there may be some kind of a dereliction. There may be some kind of a, say, the irregularities which I have committed. For what purposes? The purpose is the quantum of the punishment. They may say that if the bank has not suffered any pecuniary loss,
Yeah.
then in that event, does it invite a removal or dismissal for service? Or it may invite a lesser punishment.
That is
Can you not permit them to take a defense?
that is altogether different things.
I am again saying, so denial of a opportunity to defend is a violation of the principle of natural justice.
The series of decisions law which say that a document, if it is withheld, which will not cause prejudice to the delinquent, then
That causes that's why I say the recent departure. So you are talking about 1960, if I remember, just 60, 61 or those concepts were there, the question of prejudice that comes.
yes.
But now it says that the question of prejudice has to be judged, no doubt, because the departure, previously it was that any violation of the natural justice cannot be condoned. It has to go. Then the departure came, it says that it is not necessary that every violation of the principle of natural justice will entail the entire action. They must show what is the prejudice that is caused to him. Now, this departure has come. Question of prejudice was ingrained and infused into it. Question of prejudice is not to be judged by you. Prejudice to be judged in the perspective of a person who feels to be prejudiced.
That was the case to.
Then I would say it's a clear case of a bias. If you think that no, it is not relevant, that means you have a pre-notioned mind, predetermined mind, that even if those documents would come, I will throw them in.
No, but the question of the disproportionate punishment is something different.
No, this is not a disproportionate punishment. Question of disproportionate punishment will arise on the basis of the materials which are already available on the record. And then the question of shaking the conscience, pricking to the conscience of a judge will arise. The court will not interfere in every case disproportionate out of his own notion.
I think I often do not remember now that Honorable Justice Mr. Shah, as he then was Probably there is a decision that in case of violation of principles of natural justice, the court should not ordinarily direct reinstatement.
No. We are not talking about a reinstatement.
Now your perception is what has happened. It is almost amounts to reinstatement.
Sir, that may be a case that the entire proceedings from a particular stage where there has been a violation of the principle of natural justice, the court can quash and set aside, may relegate that from that stage where the violation is perceived, you continue. But the difficulty is, in the meantime,
He has retired.
and it is not a case of a financial embezzlement, financial loss, or a financial irregularities where you can continue there even thereafter.
There is
Yes. Whether what you say. You should do that.
The second charge was not on. The first charge was not on. Let's presume that you will not be aware whether the branch manager is authorized, whether he is in charge in that day or not. The second charge of opening of the account will not. The plea is that I was not in leave on that day. But that password is exclusive to his. And it is in respect of not 9 accounts. It is in respect of those 2 accounts which has been opened and subsequently found to be
Sir, there are 2-3 aspects I have seen. That those aspects are that yes, definitely there may be some kind of irregularities in discharge of the duties. There may be some kind of a violation which he ought not to have made. But again, I am saying that whether removal of service or dismissal from service was a proper way when the bank admittedly did not suffer a pecuniary loss, not a single penny he suffered.
money has not yet been recovered.
He has deposited. He says that he wanted, that audit report says that everything is deposited. Can you? Who has given you a wrong? Sir, who has given you a wrong instruction? Huh? I can understand. There is no difficulty.
Well, that is these are the only things. My first point is that there is no.
No, there are 2 points.
Bias.
There are 2 points in your favor.
Right.
One is the writ court should not substitute itself as an appellate authority and go into reappreciating the evidence or go into the deep of that. You are correct. Cannot. And secondly, you can say that so far as this bias is concerned, the writ court should not have gone without any other materials which is forthcoming before him.
Right. Now, moreover, in a major.
But again, on a larger perspective, I think the justice is paramount than the technical things.
Your Lordship, but these are my 3 contents. The Lordship takes down the note. After this, may not.
He is also. Once he concedes certain facts, then I said that is the law.
I am not
We can't.
considering, but after my Lord Chief Justice has told justice is paramount and the person has retired, you know, I am not considering, but I am
No,
not
we are-
able to give any fitting reply.
Maybe wrong word used while introducing you to Honorable Chief Justice.
I cannot make any further submission after this. This is the ultimate, you know. We are all here for only one thing. That is to uphold the majesty of law and for justice.
That brings to the conscience. Kindly visualize, had it been a case, show us that there was a pecuniary loss.
That's it,
Bank has suffered. We would definitely, and I assure you that even a 1 penny cannot be condoned because they deal with the public money, and if there is some embezzlement of the money and the loss has suffered, may not be substantial, but still.
Not on the face of it, the person who sanctioned the loan and the loan account has been opened by the persons holding the same title. So it shows the complicity, and those are fraudulent accounts. But in view of whatever
It's not a fraudulent.
those were not
Mr.
fictitious
Counsel,
accounts.
that's the only thing. A fraudulent means that something was done with sinister motive
Well,
to have a certain gain.
yes,
What is a gain?
that is what has happened. The person who sanctioned it was the assistant manager. He is Sardar. Then 2 accounts were opened in the name of Sarla Sardar and others. We have established that they are relatives, but the very title shows that there was something. Then these loan scheme was not meant for
Are
all.
you sure you are a very veteran in the senior counsel? Whether the surname, identity in the surname, whether that creates any kind of a linkage. There are many of the same surname.
That is right. Not on the case of the
But presumption,
not
no
having
question of presumption.
authority
No.
to sanction the
That
loan.
is what you are correct, but that is what, whether it invites such a drastic
That is
the decision when admittedly, may I use the word admittedly, the bank did not suffer any pecuniary loss.
About the deposit part of it, I will probably not.
Because if it is a fraudulent one, then no money would have come.
That they were not
Fictitious person gone with the money.
under the scheme, my lord. Only after detection they have deposited. That money was not under a scheme, my lord. That is KCC scheme. One has to be Kisan to Jalali, not anybody for that purpose.
Have been reinstated in this way. The court could have directed from the stage when there has been a violation of the principle of natural justice to continue. but not to be the entire thing.
That is probability when after.
As is not attributed to me at all.
The position is because of the subsequent event. That's the whole problem.
That was your.
And a clause,
I was
a clause.
telling about the decision, my lord. Year 2020 Supreme Court 1551. State of UP versus Rajit Singh.
Rajit Singh. So you know, sir.
It is my profession. I earn my livelihood out of it. Absolutely not.
What to do? This could not have been done. And how the single bench will substitute himself as the inquiry officer or a disciplinary authority, go deep into the evidence, scanning the evidence, finding out the one fault from here or there.
What are evidence was there, my lord? That is only proof for
What?
The evidence, there is no evidence at all, my lord.
What is the evidence? They have collected that these accounts were open
Opened
by you
no,
under the direction of a person who didn't have the authority,
It was sanctioned by the manager.
whatever. And then he says that the password, which is absolutely allotted or exclusively allotted to you, and those have been used. That means what?
That part has not been encouraged into account, my lord, because I was on leave. That was proved, my lord.
Then how one can get an access to your password, which is absolutely private to you or personal to you?
Yes, I have that was the findings of the inquiry officer also. They could not have been attributed to me, my lord.
Then in that event, what to
cannot be directly responsible for this.
This alone will legal chill, that cannot be get possible.
Sir, anyhow, now he has retired.
No, I leave it to your lordship.
Yes.
Your lordship only notes down my contents.
Yes. The judgment of the single bench is assumed in the instant appeal by at the behest of the appellant on multiple counts, namely, the single bench ought not to have substituted itself as the disciplinary authority by reappreciating the evidence, nor could have proceeded to set aside the punishment inflicted upon the respondent on the ground of bias and the principle of natural justice, or a violation of the principle of natural justice. Admittedly, the respondent was served with a notice contemplating to initiate a disciplinary proceeding against him for the misconduct. As the misconduct reflected in the articles of charges and the statement leading to it, in not only the disbursement of the amount, but opening of the accounts by using the password which is exclusively allotted to each of the employees of the bank. The proceeding continued. The disciplinary proceeding continued in presence of the respondent, and amidst the pendency thereof, certain documents were sought by the respondent, which were admittedly not provided to him. Perceiving the same, to be a blatant violation of the principle of natural justice, the challenge is thrown to the entire proceedings, disciplinary proceedings, which culminated into an order of removal or dismissal.
Dismissal.
Which culminated into an order of dismissal.
May I interrupt you for a minute?
Yes.
The Honorable Singh has also directed that the order is not implemented within 4 months to bear an interest at the 6% per month.
Per month or per annum?
Per annum.
Per annum.
That your lordship will take it.
But disbursement has to be done within the reasonable time.
This person, your lordship, will kindly fix the time.
Yes, we.
Culminated into an order of dismissal.
Start. This sentence is start the sentence.
Perceiving the same to be a complete violation of principles of natural justice, challenging the entire proceeding which culminated into an order of dismissal.
The writ petition is fine. And the single bench has set aside this order, which is the subject matter of challenge in the institute. The learned senior counsel appearing for the appellant fervently submits that the violation of that mere violation of a principle of natural justice does not ipso facto render the decision infirm and or illegal unless if prejudice is shown by the delinquent in not supplying the documents as requisitioned by him from the disciplinary authority. He further submits that the imputation of charges is grave in the perspective of a banking business where the public money is involved, and any disbursement of the amount without the instruction or sanction of the proper authority is always viewed as a serious misconduct. He further submits that a bank employee cannot now, if the bank employee is not expected to disclose the password allotted exclusively to him to be used for opening an account, which was subsequently found to be a fraudulent one. And therefore, such misconduct is not pardonable or condonable. And there is no infirmity and or illegality on the part of the authority in imposing the major punishment, major penalties. Next one. The counsel for the respondent submits that the documents as requisition in and during the pendency of the disciplinary proceeding was never supplied, and it is and such and therefore the authorities not only acted with the predetermined mind akin to a bias, but also in flagrant violation of the principle of natural justice. He further submits that there is no pecuniary loss suffered by the bank. Even such allegation is perceived to be correct, and therefore the documents which the respondent felt necessary during the inquiry or during the disciplinary proceeding, if not provided, is a violation of principle of natural justice and causes severe prejudice to the respondent. Stop. Next. On the conspectus of the aforesaid undisputed facts and the submissions so advanced before us by the respective counsels, let us examine whether the judgment of the single bench warrants any interference on the settled legal parameters occupying the field of service jurisprudence. It is no longer res integra that the disciplinary proceeding shall be treated to have been vitiated if the same is conducted in blatant violation of the principle of natural justice. The legal maxim audi alteram partem is ingrained into a legal system and is regarded as a fundamental principles inviting a strict adherence as strict adherence in any judicial, administrative, or quasi-judicial proceedings. The person cannot be condemned without affording a fullest opportunity to defend. nor the authorities can proceed to decide the fate of the proceedings without affording an adequate opportunity of hearing to the person who would be affected by such decision. The principles of natural justice gained momentum in a judicial parlance, and a paradigm shift in its journey can be seen, where mere technical violation of the principle of natural justice may not entail the entire decision liable to be struck down unless the person who perceived such violation produces the cogent materials that it causes a greater prejudice. The prejudice is a relative term and varies and its applicability is done in a varied form depending upon the facts and the circumstances of the case. The prejudice may not be construed as a technical rule, but it strikes at the root of the cause and denial of opportunity. Of a meaningful representation and or participation in a disciplinary proceedings. The contention of the learned senior counsel appearing for the appellant that the documents as requisitioned by the delinquent had no bearing on the charges framed against him may in general sense appears to be attractive, but equally the court cannot overlook the fact that the document which is in possession of the employer, if requisitioned by the delinquent for the purpose of his defense, the denial of providing such document has a cascading effect on a denial of proper opportunities and the violation of the principles of natural justice, as well as the prejudice to be caused. whether such documents will be of any considerable value in the perspective of the charges is to be decided by an authority by providing proper reasons, but cannot deny such document to be handed over, which would lay the foundation of a defense in a disciplinary proceeding. Full stop. We appreciate the submissions made by the senior counsel appearing for the appellant, that the writ court should not act as an appellate court and reappreciate the evidence of the disciplinary in the officers, but should confine its scrutiny within the four corners of the legal legal parameters as set forth in this regard. The scope of Article 226 of the Constitution of India in relation to a disciplinary proceeding is within the limited compass to be exercised within the contour of law, and the writ court cannot put itself into the armchair of the disciplinary authority, being the fact-finding authorities. The limited scope of interference against the disciplinary proceeding is well recognized to be exercised on a manifest violation of the principle of natural justice, departure from the statutory provisions, fairness, impartiality, and the transparency shown by the disciplinary authorities, tainted with bias or of like nature, above all, violation of any of the rights guaranteed under the Constitution. Stop. The aforesaid principles are mere or less illustrative and not exhaustive, as in an appropriate cases, there may be an other incidents where the writ court can interfere with the order of the disciplinary authority. In the facts of the present case, the single bench not only found a flagrant violation of the principle of natural justice and the act of the authority to be tainted with bias as it acted with a predetermined mind but the ultimate punishment inflicted is shockingly disproportionate to the gravity of the charges, which shook the conscience of the court. Stop. We cannot overlook the fact. Now, we cannot overlook the subsequent event. Happened during the pendency of the proceeding that the respondent has attained age of superannuation. And therefore, the single bench taking into account these said fact directed the monetary benefits admissible to the post held by the respondent to be paid within a time frame, with the rider that in default of the payment within the stipulated period, it may attract an interest at the rate of 6% per annum. We are not unmindful of the proposition of law that the court should not set aside the entire disciplinary proceeding if the violation of the principle of natural justice is found in the midst thereof, but should have set aside the proceedings from the stage when the court found the authority to have violated the principle of natural justice, but in a peculiar facts emerged in the instant case, that is that the respondent attained superannuation in the meantime. In absence of any charges of financial embezzlement or a pecuniary loss suffered by the bank,
Is there. Pecuniary loss is there.
we do not, article of charges says pecuniary loss.
No, the article of charges.
So that is what is the case. I find it says that there is no loss, pecuniary loss. Entire money was deposited.
No, money was not deposited, my lord.
Have you made a charges?
Well, that is the finding. He has accepted that. Though
Which
he-
one? So that has to continue. Oh, sir, I asked you many a time.
That is.
Where is that? Because I find that it says no pecuniary.
But the disciplinary authority says that for this loss, only CAC charge officer cannot be made singly responsible. Then the culpability is there.
So culpability of the then he is not responsible. He has not been found.
Page 47 of the.
But this is not a case because have you deposited the entire money? That was.
No.
I have not paid.
Means the person in
They have deposited.
full.
Yes.
No. The bank was exposed to financial loss, if any,
What?
but for the reckless advances without following the guidelines, general rules, and regulation issued from time to time by the head office, by the officials
Correct.
who are primarily responsible for such. that was the fact system on the basis of proper prepared was authorized and verified to the officer. Therefore, fixing responsibility on the CSO for this would be injustice. That is the disciplinary authority finding that alone the person cannot be held responsible. But after restructuring, that was outstanding is shown. It was first made NPA, then there was restructuring, and it was.
So restructuring was done by you under the RBI guidelines.
Yes.
So once you have permitted,
is outstanding, my lord, but
no, permitted because that is the one-time settlement which the bank has undertaken,
No,
and then restructuring the loan, and then the payment is done.
no, no.
What is this?
It is categorically done that way.
Oh, sir, I have not found. I have found that there is no. No, I do not find.
May look at this disciplinary authorities order.
Then entire exercise which I have undertaken will go in vain.
No, there is loss, but the charge officer cannot be held responsible. That is
Whatever. Then he is exonerated. You have not challenged that.
charge officer is solely not responsible.
No.
That is the finding.
In absence of any charges of financial embezzlement.
No. We could have what the earlier sentence.
If they are not unmindful of the proposition of law, which are the court should not set aside the entire
Correct.
proceeding. If the violation of principles of natural justice is found in the list thereafter, what should have set aside this proceeding from the stage when the court found the authority of violated principles.
Natural justice. Then
What in it?
What do you mean? Case.
And
Yes.
the respondent attends superannuation in the meantime.
In that meantime, then
In absence of any charges of.
yes. In absence of any no, sorry. The disciplinary authority made a categorical finding that so far as the pecuniary loss is concerned, the delinquent respondent cannot be held responsible alone, and therefore did not proceed to inflict and therefore does not found the same to have been proved. So, what is sought to be, what is held is that there may be many persons responsible for the same, and therefore the petitioner, the respondent cannot be held responsible. Cannot be held responsible. Full stop. Since such finding is not assailed by the bank in a counter,
that is evitating case punishment order. There is a loss of 3,03,864.
but he was not held responsible alone.
He was held responsible, but the vigilance officer says that he cannot be
Held responsible. That is what is solely. That is what is it.
because others were also involved in sanction and other.
Where the authorities found that the petitioner cannot be held responsible solely for the same.
Your Lordship
But-
right that the authority held, not that your Lordship right that since the entire transaction was, he was a part of the transaction.
So and the materials produced before the court does not reveal that any further steps have been taken against the other persons as found by the said authority. We do not find that
Further against
we do not find that there is that the petitioner can be that we do not find that the disciplinary proceeding shall continue even after the retirement of the respondent. And stop. For the reasons as aforesaid, we do not find the ultimate decision of the single bench to be informed and or contrary to the settled proposition of law. Stop. The appeal stands merit. Dismiss, no order has to cause.
About that.
Oh yes, sorry. Not dismiss. No. কি বলেছি?
The alternate
No, we
petition of-
no. Get it. তার আগে করে দাও. However, we appreciate the contention of the appellant that the single bench ought not to have. Where is the ultimate decision? Ought not to have directed.
54B. Last paragraph of the
That is page 45.
Just 45B.
Is where it is?
Paragraph 34B of the judgment.
Because we have gone before this court before 4 months. 30, as if page 45.
Yes, sir.
The exercise for disposal of such benefit.
Lago.
petition.
We keep what we have said, that we appreciate
the person
of the appellant that
that
the court ought not to have put the default clause, that too by awarding the interest to be calculated from the date of the age of superannuation till its disbursement. Since the disciplinary proceeding was initiated, resulting into the dismissal from the service, the single bench, after setting aside the decision of the disciplinary authority, ought not to have directed the interest to be paid from the date of the superannuation, unless there appears to be convincing material in this regard. Equally, we cannot overlook the fact that once the order of dismissal is set aside, it entitles the delinquent to receive the pensionary and other retirement benefits attached to the post which he held at the time of the said order, and therefore the authority cannot shirk their responsibility of making those payments which are statutorily recognized. How much time?
3 months.
We therefore direct. Sir, we can do it. The interest, if you do not pay within 3 months, then what will happen, sir? It should carry from the date of the judgment, I can understand.
No, because we challenge this writ appeal was pending within the
So
period of 4 months.
we can extend the time. We do not want to interfere with this. We can extend the time. It was said within 4 months you pay. You challenge the order before the single bench. Now we are dismissing it. So we can definitely extend the time for payment Otherwise, interest will not be granted.
From the date of the punishment order, can it?
Sir, but if we extend the time as the payment is made, there is no difficulty.
If your lordship says that the pay it within 3 months,
That's all.
authorize it to let it.
Absolutely. D'accord. We appreciate.
We put that for direct purpose.
No. Earlier. This is an intervention.
From the date of that.
This matter will become operative if we do.
From the date of the judgment, don't worry. Yes.
Therefore, the authorities cannot stop the responsibility of making those payments, which are statutorily recognized. We therefore direct.
We further find that because of the pendency of the instant appeal, the time limited in the impugned order has elapsed, and therefore we extend the time for disbursement of the pensionary and the retirement benefits by 3 months from date to stop. In default of the payment within the time indicated in the order, the interest at the rate of 6% per annum shall be paid from the date of the judgment passed by the single bench till its disbursement. That's all, sir. Thank you.
Sorry to have bothered you.
No.
I should have been better prepared about that part of the pecuniary loss.
Yes, I think your instructing counsel did not instruct you properly.
So let us keep it in between ourselves.
Yes.
Brothers.
Yes, thank you. So can I come? Huh? Can we come after 2 minutes?
No.
Sorry, I detained you.
Item number 7, sir.
Let's see that matter. Where I was trapped in that 82 Supreme Court 149. The withdrawal of the restriction and I can't appeal. That's that order. We have discussed it last night in detail. So today, Lord, I have only 2 things. One is to seek indulgence of my lords for one innocuous prayer. Other is the lordship will give me liberty. I'll go back to the same court for review. But before that, I have only one request. If your lordship will exercise the judicial consent, Lord, I may not be required to go to that court. Lord, today the problem is IDCO is taking over my property.
So you are borrowing that expression which I did to the senior counsel. Justice is paramount.
Exactly. Without interfering in this order, without insisting on this appeal, I just want an innocuous relief with your lordship's indulgence. I'll approach the IDCO because IDCO is taking over my property. Let the IDCO consider my grievance and pass an order. So without going to that court, I can get the same relief. Same relief from that court. That's
Which court? Which court?
Court means this order is the lordship will read the order. The learned lawyer has withdrawn the.
No, that's true. That is what I've seen. The which order you want to go? You say you want to go to some.
My grievance before the honorable single judge was IDCO, which is state instrumentality, is taking over my property without payment of my compensation. That's the whole issue. Today I am requesting your lordship if I can be allowed to represent IDCO with my grievance. Let the IDCO consider and pass on. That the all it can be done.
As a innocuous prayer.
Completely innocuous.
Innocuous prayer, although state has been arrayed as a party, but if your lordship will look at the cost title, it is represented by MD IDCO. For IDCO, Counsel Mr. P.K. Mahanti, senior advocate, he was appearing before the honorable single judge. So,
where is he? Can you secure his presence?
I get it.
Get him at 2 p.m.
That's right.
Pranay Mahanti.
I'll intimate him. I'll get him at.
Please get him.
His senior. His son is.
Pranam Mahanti. I'll intimate Pranam.
Yes.
My learned friend will intimate Pranam.
So secure his presence at 2 p.m. So that we can.
So grateful.
Item number 8.
Item 8 also.
That is similar to item 7, what I have now. Page 41, my lord, kindly see. That is the on 12/3/2025, being prima facie satisfied, the honorable single judge has passed.
You want you want the imposition of costs.
My lord, withdrawal with a cost. My lord,
That is what I'm saying. You are
and there no reason. There is no instruction.
no. The reason is wasting the valuable time of the court is the
There is
reason.
no other thing, my lord. There is no instruction,
Whatever.
no counter. My lord, your lordship is here every day, my lord, saying the reasons which is apparent, which is may come in future. That reason. There is no reason, and we have been penalized.
No. You are seeking a withdrawal, but the court has said that you have wasted a considerable period.
That is the benefit of the bar. How can we grow if we will not submit, your lordship? We may be, my lord, fools, but we are not crooks.
No.
That's why I'm saying.
Don't use these two expressions are not appropriate, madam.
Why are we penalized?
It really impinges upon the entire fraternity.
That's why.
Don't say so.
You entered, my lord, why he will be penalized? Because of some mistake he has done. Because of that. That's why I'm praying, my lord. Your lordship may.
Cost is not penalty. Cost is never penalty. Cost is cost.
But a junior advocate, my lord, my junior means new entrant, my lord, who has filed that rate application.
Where is he?
My lord, that I will.
Where is he?
I will tell him to come.
Tell him to come.
My lord, your lordship may say that. No.
What says it? You secure his presence?
My lord, I will.
At 2 p.m. you secure?
Yes, absolutely. This is government.
2 p.m. Secure. Who was this? Gopal Krishna Behera?
No, my lord, that.
He is not junior counsel. He is not junior counsel.
No. His name was Abhilasa Misra, my lord, and associates. He has filed this case and
before honorable single judge, Gopal Krishna Behera.
His name is recorded. I was not there, but this 5,000 cost.
Who has filed withdrawal memo or petition?
Abhilas Misra, my lord. Everything is there. The enrollment number and phone number, everything. That I will call him.
Call both of them.
That is record. Appearance. Abhilash Misra.
Whether Gopal Krishna Behera appeared?
No.
That didn't
Appeared.
No.
So you call? No, he also
never
appeared.
filed. No, he never filed.
But he was engaged. He was engaged as a senior. Call both of them.
My lord.
2 p.m.
Abhilash Misra is 2013 enrollment.
My lord.
2013 enrollment. Abhilash Misra.
Independently doing cases.
He is not junior now.
No, just independently doing cases.
11 years practice, you say junior. Nowadays there are no juniors in the bar, it seems.
Yes, call the next.
Item number 9.
May I Your Lordship, may I see the last order? The Lordship directed to State Council. What about the inquiry report which has been conducted by the authority? And also they have taken time that they will produce the inquiry report.
Where is Miss Aishwarya Das? She appeared. Last occasion.
Item 9.
Tomorrow you'll actually get it filed.
This one, not 13 minutes.
No, that is the order was that she prays that inquiry has been conducted, but the report is awaited. She prays for an accommodation, so the inquiry report may be placed. So she has to place the inquiry report.
Oh,
Where is she?
You are not assigned with that.
No, your lordship. Maybe passed over, your lordship. Mr. Bimdi sir has the file.
Let her come.
2 p.m.
Has she come to the court?
No,
So then what to be?
Mr.
File is
Second, that file has been assigned to some of the state.
Their files are not assigned to one.
Okay.
So on a particular day, 1 to 10, some 11 to some.
Yes. Tomorrow.
Man.
Next.
Item 10.
Well, my lord, here the virus of the statute has been challenged.
So now the Advocate General is
Advocate
given a
General will
notice.
appear. We will also file a counter affidavit. This the
This dismissal along with this.
the period of commutation pension.
Commutation of
The restoration.
Commutation of pension.
Aye. The restoration period from 12 years to extended up to 15 years.
So this is where the
Number of papers are there, man.
Batch of cases.
these are all tied up cases.
That's to be
This
tied up.
expression I have gathered here.
The common question involved. Same.
Then after
Validity
Validity of
of
the.
executive instruction.
No.
No. It's contrary. It says
The
that
amendment brought to this.
amendment.
2015 was
No, but
retrospective.
caption heading is, I think,
No.
I am
This
misguided, I think, by
no.
this
They are
caption heading.
challenging sub rule 1 of rule 7 of the Odisha Civil Service Commutation of Pension Amendment Rules 2015.
But statutory rules cannot overridden by executive instruction or executive practice.
Well, initially there was the
Caption
executive
heading,
instruction.
I just got,
Initially, there was the executive instruction.
Then subsequently amended.
For 15 years. Then subsequently amended the law.
In the month of July.
you have filed counter, no?
Not filed.
No, they
None of the cases.
None of the cases. Because recently all these cases were listed. All the cases.
Extended 2 meters are there, not used.
Mr. Ganeshwar Sarpati, that advocate for the petitioner submitted that by way of this recruitment challenge laid to sub rule 1 of rule 7 of the Odisha Civil Services bracket commutation of pension bracket close amendment rules 2015. The validity of said amendment being challenged, the state requires to file. State is required to file counter affidavit. Sri Saswatas, additional government advocate, seeks 4 weeks to file counter affidavit. 4 weeks time. They file counter affidavit. List this matter in July, along with similar matters as published by Sri Parpati. So that's all.
It's 8th July. Item number 11.
Madam, the Supreme Court has already.
Lordship, we already intimated that.
Now the judgment has come of the Supreme Court. So now the Supreme Court have indicated the parameters. So you'll have to follow that. It's the law of the land. So tell us, first thing is that you will have to make an extensive inquiry where those stray cattle are there, undernourished or malnourished. Everything is to be done. We'll have to take.
This is month July, Lordship, and the next counter.
Counter, sir. That's your obligations. While in a public interest litigation, the word counter is used. State is not an adversarial litigant. State is never an adversarial litigant. Actually, the state is reminded of their responsibilities, nothing more than that.
You have to only say what are the steps and what are the
Correct. You have disclosure that whether you have taken steps.
Person to Annexure 2. Annexure 2, he has made some.
Concerned, Your Lordship, I need some time to furnish conditions.
Flagging a serious issue relating to the rescue and the rehabilitation of all stray cattle. the instant public interest litigation is filed, so that the state may be reminded of their constitutional obligations in this regard. So, Ms. Patnaik, the learned additional government advocate, submits that she needs a proper instruction whether these steps have been taken as mandated in a judgment rendered by the Apex Court in Animal Welfare Board of India versus Nagaraja and others, within bracket civil appeal number 5387 of 2000, no, sorry, mistake, reported in 2014, volume 7, SCC 547. Stop. Let this matter be listed in the last week of June.
Item number 12.
This is a public investigation filed paying to conduct a court monitor judicial inquiry
of
relating to the alleged suicidal death of a foreign national, that is a foreign student in KIT University in the month of February 16th. It's already served.
Serve the copy. She is saying that it is not served.
And serve another copy, but it is served. Right now it's served with
the second week of the third week of or first week of the election. You take instructions. She said.
the government is sitting over the matter.
If there is already a committee set up, then we can definitely let them give a progress what they have done. So that disclosure must come. So they must be given an opportunity. So the copy they have received, taken instruction and come in the first week of July.
Mr. So we are seeking to constitute a committee as the initial inquiry. By accepting that, how can
He is making a prayer.
I'll not constitute a committee for judicial inquiry with respect to certain newspaper reports regarding suicidal death of student in a particular institution.
Student of foreign national.
Student of
Foreign national.
Miss Patnaik, the additional government advocate.
We are for the OP number 8, my lord.
A copy of writ petition within 3 working days. List is matter on so and so date to enable the learned government advocate to obtain instruction.
They made an external affairs a party. We don't have any rules till then.
What are you talking about? Any interim matters? No scope. Yes, sir.
It is external affairs made as a party, opposite part number 8, but we don't have any role in this case. Anyhow.
You have the copy.
We have a copy. Yes, let's have the advance copy to us.
Mr. Prasanna Kumar Pari along with
Koibala Panda.
Sir?
K Panda, Koibala Panda.
Koibala Panda. CGC.
And CGC, madam. Yes.
Item number 13.
Sir, 8. 1 to 7, madam.
Yes,
180 bottle.
180 man.
180 ago. Yes. Call the next.
Item number 14.
14 also 180.
180 ml.
Item 15.
What they will do with 180, 190, what will they do?
Last opinion directed state government to.
What do you do with 180 ml? Why not 90 ml? Why not 750 ml or a 1 liter
That's
or a 2 liter or a 5
I
liter?
think they all give this
All have the
same
claims,
strength.
but the interim order is there for 180 ml. We have the claim.
The
60 and
strength
90, we have the claim.
Yes. The toxicity is one and the same.
In item 15, we will not have challenged the proposal of the collector for cancellation license without jurisdiction or that last
She prays for 2 p.m.
2 p.m.
She's not assigned with.
Right. Yes. Item number 16.
I may kindly be pardoned to make a mention in the morning. It's an urgent matter. Why you don't mention in the morning? There's a the urgency matter. What urgency arose after 10:30? No, that's so. Possibly tomorrow.
Item number 21.
Yes, what do you? IDCO, my lunch senior is appearing for the IDCO. All the state. What he says that, yes, I do not want to go into all these aspects. I will be approaching the authority, let him decide. The number?
7.
But IDCO or I do not know. What is it? IDCO. Industrial Development.
Industrial Development Corporation of Odisha.
This is Industrial Infrastructure Development Corporation of Odisha. That is a government of Odisha. Under the incorporated under the IDCO Act. And whatever the state government declare a industrial estate, and for any industries, we request the government to give us land, then we are. And also they give us the possession of the land. And earmark and demand.
Not disputed, nothing.
No, that's why
I'm not
created a word that creates a problem, because I came from a place where there is an organization called HIDCO. So I just thought that's a HIDCO.
HIDCO is interpreted under the Act.
Housing Infrastructure Development Corporation. So I just thought that's a HIDCO is there.
Yeah, that West Bengal must be having this kind of
HIDCO,
industrial development corporation must be.
Since your lordship's very innocuous nature of your lordship direction, that is why I am not submitting anything.
No,
because our counter is not there.
Yes, though the order impugned in the instant.
My appearance also may be recorded.
In the instant of it.
does not invite any intervention. That does not invite any interference. Despite the argument having advanced by the senior counsel appearing for the appellant that withdrawal was without any instructions, you can find that withdrawal of the repetition may not stand in the way of the litigant to approach the authority. Ventilating the grievance. Once the approach is made to the authority, it is within the competence of the authority to consider and decide the same as permissible in law. Keeping in view that there cannot be, keeping in view of the fact that the petitioner can approach the authority despite the withdrawal of the repetition. We therefore dispose of the instant writ appeal, granting liberty to the appellant to approach the what is this? IDCO. Approach the competent authority.
In fact, state government should have not closed because they have given the land.
That's why I use the word competent authority.
Yes, we'll approach everyone.
Within a reasonable time.
10 days.
And 10 days, within fortnight from date, in the event such approach is made, it is open to the authority to take a decision in accordance with law. The withdrawal of the repetition shall not stand in the way of taking such decision by the authority.
You must have heard all the counsels.
All.
So Bharti wants to ensure his presence.
Then their name will be recorded.
I am appealing for OP number 2.
Yes.
Hey, yes, no number. Oblige.
After hearing the respective counsel.
Item 8.
Grateful.
Pardon? The one pillar wrongly they have stated. State cannot represented by the chairman.
It's so that in essence he has stated Janpa. Import our Janpa.
Nobody has pointed out.
Chairman from managing director to the representative. And chief general manager land.
Yes.
So one and two.
It is always through the secretary.
That is wrongly.
Wrongly.
Yes, who is in 8?
My lord, 8.
He is agreed by 5,000 rupees.
No, my lord, the conducting council is.
I will not stand on the way. You are
My lord, conducting council is here. My lord, I have called
Yes,
him.
I was present on the day.
You have withdrawn.
He was present on that date. Gopal
Just-
Behera.
You have withdrawn it.
My lord. My lord. When the withdrawal, on the ground of withdrawal is that, on the basis of instruction received from the State Council, when advance is going to pass and the Honorable Court directed for initiation of complaint proceeding, I withdraw, my lord.
So that means should you encourage this kind of practice? When the moment the arguing counsel is found that
No, my lord, there is compulsion, my lord.
passed in a petition, so he withdraw it.
Under compulsion, I withdraw, my lord, because
Why compulsion? There is no compulsion, sir. It's an adjudicatory process, sir. You can say your point, other side
My
will
lord.
say their point. The court who is to decide who is, which point is more convincing. But it will not be compelled to withdraw. There was no compulsion which was given to you.
about the
If your conscience is the
yes,
this notion has to be.
My-
This notion has to be erased from the.
My lord, my lord.
But
my lord.
you are here to justify whatever according to your wisdom is correct.
That's all. You are here, first an officer of the court, then a representative of your client.
My lord,
You have a duty towards at least restitution to a lot of responsibility.
my lord, may I permit to say, my lord? Initially, the requisition was had, an interim order was passed, and the very next day, some instruction.
That once you have withdrawn, then what to do?
What did you do? My lord.
What do?
Because so the situation which compelled me to withdraw, my lord, is that London State Council handed over some instructions.
And not be any compulsion, sir, on your part.
My lord,
You could have said that this instruction has come. Let me take a decision on that.
my lord,
Let me go. through
I was
the
never
instruction.
allowed, my lord. I was
want
never
to
allowed.
respond. I want
That's
to-
not
Even
allowed.
if, even,
Why compulsion?
It's not
even
allowed.
if I have given a chance to reboot that instruction, I could not have withdrawn, my lord. Even if on that day, I could not have given, my lord,
You could have taken a decision of your plan,
my lord,
of your mind. Not the bench who will suggest what to take and what not to take.
my lord.
Why you will be, I am really at loss to understand that the lawyers get compelled from the bench to withdraw. This is
No,
not
no.
acceptable to me.
I have withdrawn. I have withdrawn, my lord.
Because I was there for 2019 and.
My lord, I have withdrawn. In fact, I have withdrawn, my lord. I have withdrawn.
It is not consent, you will do the work.
Because you had to interim on.
My lord, let me permit to submit, my lord. Let me permit to submit, my lord. My lord, what happened, my lord? That on that particular date is in 20th March, when the impugned order was passed, when State Council entered instruction and instruction is written that I have protested the road, I have blocked the road. In fact, I have not blocked the road. And on that ground, when the Honorable Single Judge directed towards prosecution against me, and being aware of that, I have no fault for prosecution, I withdraw, my lord.
But then you were to be bold enough to say that, yes, let them initiate a proceeding, I have not blocked. Let them find that I am committed.
That was my mistake, my lord. That was my mistake.
If you are a equal person, why you will,
My lord,
why you will get,
that was my mistake, I do admit, my lord.
will have a claim,
I do admit, my lord.
can never be belied.
Yes.
To
Yes.
share a truth throughout.
On that premises, I have
You
withdrawn.
are so much apprehensive. Why you will withdraw? You should stand by the truth.
My lord, it should be. That was my mistake.
Triumph in the judicial system.
My lord, that was my mistake, my lord. That was my mistake, I do admit, my lord.
And please, a suggestion was there to initiate a proceeding for your removal. You withdrew it so that no adverse order is passed in the proceeding. As a lawyer, we never.
Well, without petitioner's instruction.
Stand by.
My lord.
And without petitioner instruction, we should not, let it be dismissed. So that's now, my lord, without petitioner instruction, because they will file against us because the bar council. They has withdrawn without my knowledge. I told him that you should not, they let it be dismissed, let the order, adverse order may be passed, we can come before this court. But withdrawal is our act. We are withdrawing. That is the whole, that's we are facing David.
Yes. That is the judgment.
What is the judge? Make an application that it was without instruction.
Let a representation is there, be last in our 7.
That's what Honorable Supreme Court said.
That
But your lordship said right now.
No, that I know you are citing 82 Supreme Court that is solitary judgment.
right. But my prayer is, as your lordship done in item 7, my representation is there. So as K is a
There are people that once you get the benefit of the interim order and
What-
at the time of final hearing, you realize that the main matter is going to be dismissed, you wanted to withdraw. Then the court will impose the compulsory cost.
There is no counter, my lord, only 5 days for interim order. On 13th interim order passed, 28th is the final order, next date. So only 2 orders there, no counter, nothing is filed. My lord, let this case is be disposed of, my lord, your lordship knows that case, separate case,
Well,
that if any authority passed a order, it is his, they will be,
what, evening?
my lord, that is,
Any authority passing an order, he has got the authority to recall it. That's what.
they not recall it, my lord, there's a tendency to stick to that order.
Court has said otherwise.
You'll also dispose of my,
The parties there were very powerful.
my lord, it's a lot.
Sardar Srinivas Nayak's case, that case went up to the Supreme Court and this was a fight against A.R. Antole.
My lord. Yeah. Well, our judgment. But why only pray?
Our High Court permitted to withdraw, that went to Supreme Court, the other side went to Supreme Court, saying that once you have entered the interim.
Yes.
Yes.
Right.
As an interim measure, you could not have withdrawn.
There is no way
not to compensate the other side. The Honorable Supreme Court has said, court order should tell this now, then impose interest. That is compensatory interest.
Well, that's the law is, my lord, in the factual, my lord, this case, only 7 days. And
Why you need you?
And that's my lord problem.
Go there and say.
Yes, my.
Not my intention to withdraw. There was no instruction. There is nothing for the to close the single judge.
He will go there. He has filed the case.
He has to go there.
He has to go there. Only that 5,000 cost. There's a penalized, my lord, we have been penalized for withdrawal. That withdrawal is subject to condition 5,000 cost to the bar. That may be modified. Bar association. My lord, without instruction, he withdrawn and he will pay 5,000 cost. My lord, the client will file a lodge an FIR against you because he withdrawn and he is asking for 5,000.
You intimate the of the beginning of the part.
What else, Mr.
So, those are good stories. Appearance and subject. So, because to show, you appear into the same solution. That he then. Though the withdrawal was. Though the sufficient, to show the prayer of the withdrawal was done, but. There was no instruction which he received from his life. The procedure to order, but or addiction is gone to a judgment of the ethics court, then that in case of state of Maharashtra, which is now the Srinivas Nayak. Reported in AIR 1982 Supreme Court failed down that means by interpretation to direct in an analytical solution. The court has that if there is a wrong record or recording or the recording which is not sufficient by the proposition. It would be proper for the litigant to approach the same judge. Before pleads, yes. Before it pleads, before the event pleads from his members. The order included in the instant appeal is passed on 20th March 2025 and therefore of a recent origin. And we do not think that the connection forgotten what has happened on the same day. In view of the ratio of lower way down in the above noted decision, we permit the applicant to close the same job, to pass the include order. Exactly an issue which is raised in the inside. Though we respect the sentiments of the non-executive judge on the wastage of the time of the court, but considering the other passage of the issue, we feel that the imposition of cost is too burdensome, and therefore the portion in which the cost is imposed is hereby set aside. Liberty is granted to the appeal to oppose the impact.
If cause of action.
Within fortnight or within I don't think we are having can you go within this week?
Well, after vacation, that cause of action survived.
First speaking.
If any cause of action survives, if any cause of action survives,
If any cause of action survives.
It's
Means the reputation was filed on that without any acquisition, they are.
I am asking, sir, what do you mean by this? We have given you liberty to approve the court for recording of something. Which will expand.
Yes.
That will happen.
And then you are saying the cause of
No, the cause of action survived.
I will really at loss what you say.
My lord.
Take our assistance
No.
there. One after the shooting of this war, following the law. Out of shape to pass.
Sorry, no, sorry.
Practically, we have gone beyond our domain.
Your place, my deep you place.
Actually, it is unexpected. You conceive.
Yes, next.
In this matter, Lordship's last opinion directed State Council to obtain instruction whether this letter of the collector under Annexure 12 is without jurisdiction, and I have cited judgment of this on court, and he has no power to propose for cancellation of license.
Why the matter? Oh, the instruction.
Yes, ma'am.
I'll pray. I'll pray my lord some more time. No instruction I have not received, in spite of the fact that I wrote a letter to them. I have not received the specific instruction. Sometime in the time.
Time nice. This holiday will be there. Lordship, I have against the order of the collector, I have filed the
Your
appeal.
Lordship, may kindly-
The appeal will be decided on it. While
Passing this order, on same day he has, to
The-
cancel the license, he has given the letter.
Yes, I understand that the impugned letter.
Yes, my lord. Against the, under annexure 10, the order. No, my lord, it has not been numbered, is it?
Your lordship.
Let that.
Your lordship directed the appellate authority to decide the matter within a stipulated period.
Without influence by this, my lord. Yes.
Annexure 11.
Yes, I have given, appeal memo I have given, annexure 11. No, that is not been numbered, as yet. Yes. I have filed it on 11/4. 29/3 is the order. This is not I have filed. Base 54 in bottom, seal is there.
Yes, I am holding that. I am holding.
Yes, my lord.
I am holding.
11/4. I have. In bottom.
It must have been filed. Without that, seal could not have been there.
Yes, I have filed it, but I personally I have filed. Lord, letter 29/3/2025, annexure 12.
Application for compounding the
Yes.
offices as per section
5.
5 and 8 of the.
Yes.
Excise Act.
Yes.
And for renewal of the license.
Yes.
Was rejected by the collector.
By the collector.
In fact, you have gone to a commissioner.
Lord. Annexure 10 is the order. Against that I have filed up.
By an order dated 29/3/2025. After the collector. The application by the appellate. To compound the offences. Saying 75. Read this section 16 of the Odisha Excise Act 2015. And rule 58 of the Odisha Excise Act 2017. Was rejected. The further prayer for renewal of the license or permission to continue with the online shop. Continue with the online shop. Yes. Continue with. I have a restaurant shop. For the year 2025-26 was also rejected.
Lord, renewal is not rejected. Only they have rejected with the compounding offense.
That means the renewal is
Yes.
also automatically
That's-
slightly rejected. The appellant has filed an appeal. Sorry, the petitioner has filed an appeal under Rule 25 of Holy Rules 2017.
What is excise?
Before the Commissioner of Excise, Odisha.
Yes.
On 251, sorry, Rule 250. On 11/4/2025. But he has neither been assigned any number, nor has been given a notice of, notice fixing a date for hearing of the Senate. The present petition is by raising such grievance, more particularly the inaction on the part of the Commissioner of Excise from Cuttack in not registering the said appeal. So, on the earlier occasion, the matter was adjourned, enabling Mr. Das to take appropriate instruction. But still, Mr. Das gave me something that despite the communication that he concerned officer, he has not received any instruction. On perusal of annexure 11 at page 54 of the petition, we find the receipt of the office of the excise commissioner. With the signature and the date appended there. which indicating that the said document was received by the office of the Commissioner of Excise. The statutory provision confers right of appeal before the authority, and once such appeal is filed, it is a duty of the said appellate authority to assign the number and hear out the matter in presence of the party included there. The appellate authority cannot sit tight over the matter, and it is inconceivable that despite the receipt of the appeal, no number has been assigned, which renders which inculcates a sense in the mind of a appellate that he would not get a proper justice. Be that as it may, the document so annexed to the petition is suggestive of the fact that the appeal was filed before the Commissioner of Excise, Orissa, and therefore the proper number should be assigned thereto. We therefore dispose of the petition directing the Commissioner of Excise, Orissa, to assign the excise appeal number to the appeal filed on 11/4/2025 by the appellate, and after the notice is given to the respective parties, to respective respondents, endeavor shall be shown to dispose of the same as expeditiously as possible. It is open to the petitioner to apply for any interim order, if so advised, before the Commissioner, which on its filing shall be decided in accordance with law.
Simply that may not be required because your lordship, if your lordship sees Annexure 12, this is a proposal only. No order of cancellation is there, it is only proposal.
I am
Proposal for cancellation.
my submission is that collector has no power to. Lordship may say that commissioner will not be influenced by this decision.
Since we have not gone into the merit of the respective contention of the parties. None of the observations made here hearing above shall have any persuasive effect upon the said appellate authority deciding the appeal on bail. Please. The Lord continue.
Party convener on 5/4/2025, the lordship directed me to take instruction as to whether the order has been complied with or not. I have received the instruction, but have not filed the necessary.
Complied or not?
Complied,
Complied or fully complied?
Substantial portion has been complied. Last step is there. Before the government, after government, it is not. The lots of people find that on first page, the step second page up to 5, my lord. These documents are. There was a direction. Action was, my lord, this court directed the author to take a decision on the objections filed by the petitioner within a period of 2 months. That was the direction. We have taken steps.
File an affidavit so that they will get an opportunity.
Under section 46, objections were filed, this honorable court was pleased.
Disclose
Such a direction. Actually, the astronomical increase in benchmark valuation. Whereas the per acre in Bhubaneswar, it is only 2 crores, whereas it is 24 crores in Ganjam district. It is not possible even to effect settlement, to effect partition in the family, to transfer the land, to sell the land, even to execute and ceremony, gift it as and when required.
Gift it, where is the difficulty?
Because the stamp duty is
The percentage is very low. In gift, what is the percentage here of a gift deed?
same as sell deed.
Same as conveyance.
Same as sell deed.
I think, my lord, a final step after it is taken, it will be substantially reduced.
Actually, the
Instant content.
recommendation was
Of alleging the willful and deliberate violation of an order passed in the public interest litigation. After the notice is issued upon the arrest contender, Mr. Das appears for the submits that substantial compliance has already been shown. But because of some procedural and or statutory adherence of the provisions, because of the statutory embargo having created, the full compliance could not be secured, and he prayed for an opportunity to disclose all such facts. In view of the, have you filed your objection to or counter to the contempt? No.
These documents can be filed along with
We find that though that after the notice is issued, an opportunity to file a counter affidavit is not extended to the alleged contemners. We therefore direct the alleged contemners to file a counter affidavit within 2 weeks after the reopening of this court following the long vacation. It goes without saying that the documents sought to be placed before us shall be disclosed in the said counter affidavit. Yes. Let the matter be listed after 2 weeks. He has a right to file counter under the country.
Yes, my lord.
Item number 24.
The situation is very precarious.
I understand. We understand because my brother is a partner, so understand in the perspective of a tax statute as well.
My lord knows the predicament of the local situation.
We know that it does not fetch the actual market price, but the circle rate or the rate fixed by them. Then the notional income would be calculated by the income tax authority and asked for the
Actually, district valuation committee, benchmark valuation committee recommended only 10 to 40% rise, but they have increased it to 1200%, to 12,000%.
in this way. Then.
If the sale deed of the corresponding or contiguous period is of that, then what to do?
No, that is not there.
There must be some material. Yes, go.
Item 24.
Right. Here the petitioner is challenging this adjudication order passed under section 74 of the CGSTR, whereas on the self-sale is for the self-sale.
Small objection, my lord, preliminary objection. The lordship may kindly see page 2 of the writ application. Here, my lord, the company is represented by a authorized signatory, my lord. My humble submission, my lord, he cannot represent, the company cannot be represented by an authorized signatory. It should be by the director or the principal.
Where is the law?
My lord, I have given that. Lordship may kindly say, Order 29 Rule 1 of the CPC, my lord, and the principle of CPC is applicable to this writ. My lord, I have given that judgment, my lord, which says that, my lord, our
Is this judgment?
my lord, I have given that.
97 Supreme Court, page 8 or 7 or 8.
My lord, I have not gone through that. My lord, this view was affirmed by the apex court also.
That is the SLP is dismissed.
Yes, my lord.
That does not mean that.
That is not the ratio, my lord. But here, my lord, it says, my lord, a company can only be, a director can only represent the company or the.
There are two judgments, corresponding judgments, not 97. It should be 87 or something Supreme Court, and Delhi also, the same view is expressed.
And here also, my lord, 4 apex court judgment can be considered. In this judgment, my lord, 4 apex court judgments.
There is one judgment of a Delhi High Court and there is one judgment of the Supreme Court contrary to this.
My lord,
authorized signatory can definitely do it. Yes, that is the sense of the legal. If the board of directors have taken a resolution authorizing a person to represent the company, then who are you, a third party, can raise this point?
My lord, with all due respect, but that is
produce the board resolution. That's the curable defect. They will produce the resolution of the board of directors. But we can't. So he's entitled.
My lord, here it says only
principal officer. So he is authorized person. He's a principal officer.
Principal officer, my lord.
Principal officer means what? Is this defined anywhere? He's an authorized officer. No. Yes, what is the point?
My lords, the petitioner is challenging this adjudication order passed under section 74 of the CGSTR, whereas for the self-same period and self-same issue, already the adjudication had been passed under section 73 pursuant to the audit undertaken under section 65 of the CGSTR.
So if it is a recurring one, then why not the 74 will be dropped in? In first case, it was innocent mistakes. So there was no element of fraud. If it is a recurring one, then will it not attract fraud?
My lord, your lordship, kindly have allegations made in the impugned order, your lordship, page 21, annexure 1, your lordship. Kindly have a glance to page 21, your lordship.
Yes.
Annexure 1, your lordship, that's the impugned order. So, para 2.2, second para, your lordship.
Yes.
The notice are alleged to have.
Page annexure 1.
Annexure 1, page 21, your lordship. This impugned order. Running page 21.
Yes, it's.
This second para 2.2, your lordship. May I place it?
Yes.
The notice are alleged to have contravened the provisions as laid down in section 16.2, 16.4 and 39, both Central Good Service Tax Act, Orissa Good Service Tax Act, in as much as they have availed and utilized excess input tax credit of rupees so and so during the financial year 17-18 in their 3B return as compared to ITC available in Form 2A and have subsequently utilized to make the payment for their output liability. And para 2.3, these are two allegations. Para 2.3, Audit Commissioner at GST Central Excise had issued notice on dated so and so for conducting audit as per the provisions of section 65 of the Acts and had requested to provide the documents such as copies of the audited balance sheet, including profit and loss account, gross trial balance, so and so. So there are two allegations. These two allegations are totally unfounded, Your Lordship. Your Lordship, kindly have a glance to the Annexure 2. Running page 35, where audit has comprehensively verified my books of accounts, and these two aspects has already been dealt in by the audit authorities. Running page 35, Annexure 2, Your Lordship, kindly have a glance. So that's column 10, Your Lordship. The period which
17, 18, 18, 19, and 19.
Informed period is 17, 18. What 17? Then the dates undertaken, column 11. 15, 12, 2022, this there. Then the running page 36, Your Lordship. Next page, Your Lordship, kindly have a glance. The audit report, final audit report. Your books of accounts and records for the 7, Your Lordship.
Page
36, running page 36. Next page of that.
Yes. Yes, yes.
Your books of accounts and records for the 17-18 to financial 19-20 has been examined, and this audit report is prepared on the basis of information available and document furnished by you. And the first allegation in the audit report was excess availment of ITC in 3B vis-a-vis the 2A. What these allegations have been made in the 74. Can I place this observation in during the course of audit, books of accounts, records, relevant ledgers for 17-18, it is found that the taxpayer has wrongly availed so and so. And this bottom line, that's financial 17-18, that's ITC as for 2A and so, that's the excess availment of ITC. Now, the pursuant to this observation, Your Lordship, so that's the finding of the auditor in the page 37, next page, in the bottom line, Your Lordship, that's the suggestion of the auditor, this last page of this 37, last part, this box, left side, suggestion of the auditor. In case the taxpayer fails to reverse the excess ITC under section 73, read with so and so, along with the appropriate interest, then the decision of the MCM. The decision of the MCM covers, Your Lordship, after conclusion of the audit and the finding by the audit team, this MCM constitute the commissioner, headed by a commissioner. So they are approving this audit report. That's a monitoring committee meeting. And this auditor has been approved, and they have said they agreed with the suggestion of the auditor. So they recommended for initiation of proceeding under section 73 for fastening this demand. Now at Annexure 3, Your Lordship, this 73 proceeding has been initiated pursuant to this observation made in the final audit report conducted under section 65. Now the demand has been raised and challenging this. So I assailed before Your Lordship. So at Annexure 4, Your Lordship has admitted my this petition and issued notice. Annexure 4 page, running page 76, Your Lordship. Now when the same issue, when the same issue has already been decided, verified by the audit and subsequently adjudicated under section 73. So how they can invoke, why got the jurisdiction to invoke section 74 on these unfounded grounds?
For the same assessment period?
Same financial period, Your Lordship, on the same issue.
Not
the 3B and 2A, Your Lordship. What they are alleging. What I stated in running page 21, para 2.2, Your Lordship. That's the main allegation. So the basis of allegation is unfounded. So how the proceeding is accepted? The 74, they have got no jurisdiction.
The Lordship will kindly see running page 21, my lord. Para 2.3, my lord. My learned friend has not placed complete paragraph, my lord. Your Lordship may kindly see page 21, para 2.3, my lord. It says that he has not produced any documents, my lord. That is what it says, my lord. The notice did not respond to notice under section 65 of the Act. Subsequent, even after so many communications, the notice had not submitted any document. Thereafter, my lord, summons were issued. He has not bothered for that summon, my lord. Thereafter, your Lordship may kindly turn to next page, my lord. 22 page. Your Lordship, with this background, your Lordship may kindly come to page 30, my lord. Page 30. These are not the same issue, my lord. These are other issues, my lord. Self-same assessment here, my lord, I have to admit, my lord, but the issues are not the self-same. Your lordship may kindly see page 30. Since second paragraph, my lord, it starts with since the amount already covered in DRC 07 dated 28/12/2023 is stated by this honorable court, I refrain myself from deciding on the said amount and confirm the remaining amount which is in excess of impugned order. This is not the same issues are not the same. It is not same assessment here, but these issues are not there in the first order. That is what my solution on the face of this record.
Your Lordship, the issue is regarding ITC as for 2A and 3B. Now my learned friend what is saying, then the question of law, this false.
Whether so-called notice contained this issue?
Yes, Your Lordship. So-called notice, simply they are alleging on two aspects. Your Lordship, kindly have a glance to the so-called notice, this page 8, running page 81, Your Lordship, answer 5.
Yes.
Running page 81, Your Lordship, the last para. Para 2.2, Your Lordship, the grounds in brief on the basis of which such allegations have been made, Your Lordship. So 74 so-called notice along with this impugned order. Page 81 is the notice, so-called notice for 74, Your Lordship. So they are alleging in one aspect, you have not produced any books of accounts before the audit. And second aspect, so there is a mismatch, page 82, Your Lordship, kind have a glass to last paragraph. Mismatch of it. So that they are rejected to scrutiny. Same transaction during this impugned period regarding mismatch of ITC as for 3B and as for 2A. So that means he has rejected in the page 82, the last part of this quantification, he has rejected to the scrutiny. So can he, once the audit is concluded and culminated in the 73 proceedings, and they have not assailed the 73 order. The 73 order, whatever is left out, so the department has never assailed them. And they rejected to further scrutiny. Now the question of law falls before your Lordship. When the comprehensive verification of books of account vis-a-vis the returns has been made under section 65 by conducting the audit and his subsequent affirmation in this adjudication proceeding under section 73, can they again revisit the same without assailing the 73 order and resorting to section 61 of the scrutiny and showing that there is a fraud and willful misstatement on the same transaction? On what my learned friend said, there are some differential amount, how it would attribute fraud? They have already said that there's such an amount falling within the ambit of 73 and they have not assailed it. Where got their jurisdiction? Because while invoking this, so that the limitation period has already been expanded. Under 72, they cannot mechanically resort to the 74 unless only the ingredient of 74 is there.
So WPC 10545 was under.
That is under this because this order was passed beyond the limitation period of 7310. So they took the recourse to the section 168A, the extended period. That by virtue of this force measure, whether it was there. So that is why. So
The WPC 10545.
yes, my lord.
That was under 73.
73 during this period and on the same issue.
Not do directly, you wanted to.
Oblate. Oblate.
With all due respect, my lord, as appears from this record.
Is there any fraud in? You missed to verify the.
Because my lord, he has not cooperated.
Twice you have verified.
Without his cooperation, can I do the audit, my lord? I am posing a question to myself, my lord.
Audit report is here.
Because he has not produced the records. He has not responded to my summons. Whatever the material available at that time, my lord, I have audit was
under 74.
Yes, my lord.
73 you have already invoked.
Invoked.
So no course action.
That was, my lord. So, and these impugned order that no course of action portion was not taught.
For the same ground. Again, you are invoking 74.
Revisiting, whether revisiting is permissible under the law. Once they have completed the activity.
Then this audit exercise is a farcical exercise. Then what audit is done? If there is a further mismatch, if there is a further suppression, then what is the purpose of an audit? Just tell me.
The transaction was with you at the time of 73.
You had all the materials. And once the audit report suggests that there has been the wrong input tax credit which they have availed, and the 73 proceeding has come, then fall back on a scrutiny.
Audit has been affirmed by the monitoring committee meeting. That's headed by the principal commission.
I fail to understand. And for the same transaction, failed out nothing.
Your Lordship may kindly see that these transactions are not there in this.
The issue of mismatch.
The audit have you done? You have not. Have they shown anything else? Have you found any other materials which were not disclosed or which were not there from the another's return?
My lord, to that extent, I have
Nothing. Fraud.
What is the source of this information for this new audit, my lord? That I have to examine because I have to take instruction, my lord.
Difficult situation.
So your caption heading 81, page 81. As much as notice it was availed, exercise the credit
Yes, sir.
and GSTR 2A.
Then this was already foreclosed under section 73 for the same year. 1074. That's to be admitted. Yes.
21,
22, page 17, Anisuru.
22nd January. Section 72 of the CSPS for the periods related to 70 to March 2018. The allegation of dispatch in NTC on the returns. This certificate is Kumar Committee.
Narayan.
Okay. The on earlier episode, assessment was framed,
Audit conducted.
under assessment under section 73, which was made. But to do knowledge. Same reason of the same experience. The income assessment the section 74 has been paid. It is not notice of this court that assessment from the section theoretically was subject matter is the subject in the NTC Bangalore site for where it entered my oxygen. Authority as police as one member assessment
This. Senior study. Adequate numbers of dictionaries as our US service. Private service. Same conditions which for consideration. Audit. And which problem in assessment of the same condition as subject matter of the present clinical assessment.
With the losses time permission reduction, kindly see page 30. That WPC portion has been excluded from this audit. The loss may kindly for a moment. Your loss
When a show cause notice is issued on a particular point, can you take a further point? Tell us.
We are of the view that once you have undertaken audit, then you had the material with you. And now you are realizing that he has not produced it. You had the material which he had produced under 73. From that you have called out further information and now proceeding against
Without assailing 73.
Without specifying the ingredient to be satisfied under 74.
Okay. Yes.
Is there any sufficient of material? Is it dehouse the record which he has produced?
My lord, this ordering original self it dehorsed that record. On the
maybe, but you are.
But I will go, but I will come back to your lordship with all details.
Your super notice, can you go on your super notice?
What is the main?
I will come back to your lordship with all details.
Yes.
That is how Honorable CJ has said that audit, it is a farcical exercise. Then why are you taxing him both ways? How many times he will cooperate with you for the same periods?
Great.
You'll be ready with board of directors resolution for the next.
Item 25.
May I please, my lord?
Yes. Have you taken instruction on whether it is a beverages of fruit juice, fruit drink, or carbonated beverages with fruit juice or fruit drink? When you introduced in 2021, can you fall back and
That we again under fraud.
2017-18?
Again under fraud, section 74.
Lordship, till now we have not received the instruction, but Lordship, it's an institution of rate of taxes. Let.
You should prepare yourself for instruction.
If the entry is for the first time brought in on a particular date, can you apply that entry with the retrospective effect?
Let the Lordship that it's an interpretation of rate of tax, let them file an appeal before.
That is what when
He
you
will
have
verify
brought
all the
in that
facts,
bracket,
why
but
this-
it was not there for that during that relevant period. Can you?
Sir, you should examine yourself, sir. It is purely on the comparison of notification, date chart. That's all. What was the position earlier? What is now? And whether particular entry comprehends this commodity at that relevant point of time. That's all. This is pure question of what instructions you will get. Is it any requiring any fact? Area, some six further indulgence. instructions and filing response. What have you challenged?
Get that assessment under 74, section 74 again.
The submissions made by Dr. Mr. Since the entry carbonated beverages of fruit drinks or carbonated beverages with fruit juice has been inserted with effect from 1st October 2021. The proper officer, while assessing the education for the tax period July 2017 to March 2018, has committed illegality and determining the tax liability on the basis of said entry. Right? We are satisfied that the relevant point of where parameter was satisfied that during the relevant period under assessment, the entry was differently worded. Since no instructions have been received, this lack of communication with the department as submitted. So here, no person till the next week.
Blind, go blind. Give blind.
And subscription. Answer?
7.
7.
Give your list.
26.
One in.
In family consumption.
Junior standing.
8 is the petitioner here is a senior doctor, 77 years old. Plus, he was issued a notice for imposition of service tax. The order, your lordship will kindly take page 50. Page 50. On 8/2/2024, a personal hearing notice was issued by the superintendent adjudication.
Page 50.
Page 50, 15.
50.
Annexure 1 series. Pursuant to that, I filed written submissions, which is at page 60. In that written submission, which your lordship will find at page 16, I have, my lord, given my explanation as to how I am falling under the mega exemption notification of number 25 of 2012. And since I am a medical practitioner providing services to clinical establishments, therefore I do not fall under that. I give that explanation. Then, my lords, at page 20, my lords will kindly see another notice of personal hearing was issued. Again, my lords, certain documents were asked for and a personal hearing opportunity was given. I attended it, and page 21, my lords will see some further documents also pursuant to that proceeding I submitted at page 21, my lords will see, where I submitted the written submissions 26A, 26AS, ITR acknowledgement, etc. and certificate of practice. Now, my lord, thereafter, the order in original at page 22 was passed. My lord will kindly take page 22. This is the order in original dated 9th of April 2024. My lord, it's quite interesting to note that at page 25, under the heading record of personal hearing, it says we never appeared. Whereas we appeared, we have given written submissions, everything has been done. All these, my lord, will
subsequently will fail into insignificance because I'll show what has happened later on.
He has recorded 3 adjourned dates.
Yes, but I have given the written submissions. I filed the written submissions.
On?
Before the
On?
Yes, I'll show page 16 is the written submission. There is no date mentioned in that, but it was filed. And Millard will kindly state page 21 also. It says, as per the above mentioned letter, we have submitted the written submission in your mail ID. So written submission was submitted by mail ID. On Millard's, it is mentioned at the top 14/3/2024. It was submitted later on, after this hearing was over. In any event, Millard, that will not be Millard, because later on I'll show Millard that in the appellate authority, when the matter went to the appellate authority, here, since I was showing the order in original, let me show that order in original. A demand of 2,47,000 plus penalty of 2,47,000 at page 28 Millards have been levied. The total of around 5 lakhs Millard has been levied on me. Thereafter, Millard, I challenged it in appeal before the appellate authority, Millard. At page 30, Millard, is my appeal. Millard sees the appeal. The form ST4, the appeal form, Millard, which is at page 31, Millard, may kindly take. Date of communication of the decision or order appeal against the appellant, 9/4/24, received on 12/4/24. So this date, Millard, may kindly note, is the date 12/4/24 is the date on which the order has been received. This is important, Millard, to show that the appeal has been filed within the limitation period and it could have been condoned. The delay could have been condoned in the extendable, condonable period. It could have been condoned. Millard, 12/4/24, the appeal was filed. The grounds and everything is there, Millard. Then, in course of the appeal, Millard will kindly see page 40. Page 40, your Lordship has. This is the fixation of date for personal hearing, dated 4/11/2024. Now, Millard will see in the contents of this letter,
Simple. 761.
How the 41 is come?
Same source. Well. Same source it is.
In that event,
No. My brother has a good. Anyhow, I am having the physical copy.
Yes, Millard. So in this appeal, in this notice, Millard, they were nowhere they asked for if there is a delay, Millard, like your Lordship knows, that if there is a delay that is pointed out to us, that there is a delay, kindly explain. Nowhere ever they say that there is a delay, kindly explain. They don't say that. Ultimately, Millard, I give my written submissions again before the appellate authority. Your Lordship will see, I give my written submissions 24. I filed my written submissions at page 41.
No, you filed your appeal when?
Appeal on 12/4/24. 4. I'm sorry, 12/4/24 is date of receipt of the order. Appeal filed on 12/7/24.
On the last date
Last date of the limitation
extended
period. It has been filed. Now, here, Millets, I am on the aspect of Section 12 of Limitation Act, which says the date on which the.
From the day when it is to be calculated, it has to be excluded. and
Yes.
then-
If it gets excluded,
What is the first period of specified period of
2 months. 2 months.
2 months.
2 months, then what? This is service tax, Millard. This is service tax. GST has 3 months plus 1. So 2 months
plus 1.
1 month. So Millard, since if Section 12, Millard, what has happened? The appellate authority, interestingly, Millard, I must show this, page 57, the appellate authority's order. Dated 23rd December 2024, Annexure 7. Please. Well, we'll see page 61.
Yes.
Para 2.6. Agreed by the impugned order, the appellant filed appeal before the Commissioner with a appeal dated 12/7/24. Your Lordship has that? Then Millard will come to page 63. Millard, I was showing Millard, page 61. Para 2.6, I was showing to show on the date on which the appeal was filed.
Yes.
So it is filed on 12/7/24 admittedly. Then, Millard, your Lordship will kindly see page 63. Para 5, discussion and findings. Para 5.2, sub-para 5.2. First of all, I observe that the appellant filed the instant appeal with a appeal number such and such on 12/7/24. The impugned order in original dated 9/4/24 has been issued on 10/4/24. And the appellant in the appeal petition claimed to have received the OIO dated 9/4/24 on 12/4/20. Now, taking the date of communication of the impugned order as 12. So, Millard, Section 12 has not been taken into consideration. So, had I, Millard, been given that opportunity to explain the delay, I would have explained it, but I was never given. In any event, Millard, by going into that aspect, he has said that at page 5, 2 months. Yes, Millard, we'll see page 8, that section is quoted.
Calendar month.
Calendar month. Yes.
2 months will last 11/6.
12/6. 2 months will lapse on 12/6. Here, what has happened, your Lordship will see the relevant provision is there at page 63. Section 85 is quoted, which shows 2 months and 1 month. At the bottom.
What is the definition of a month?
Month, Millard's calendar month, it denotes a calendar month. So it has to be Millard's 12 to 12/30.
On this very issue, how to recent rulings, around 4 to 5 years within this board. But name and property our High Court judgment
Yes.
wrong.
There is one judgment of Calcutta High Court which says that Limitation Act shall apply to these appeals.
2 months.
Balance.
It is February. In between.
Let's.
It has said, if I previous the second one. He is correct in saying.
Yes.
Perhaps, you have to read that.
Previous day of the second month.
It has done in CSTR.
I will examine.
I have read some.
I will examine, but even if that is the view also, still I am within limitation. If it is previous day of the second month, then the first day is excluded. 13th. Yes. I am so grateful. And the appellate authority says that there is no merits in the demand and says that demand is not maintainable. But his hands are tied because of limitation. In any event, it is exempted.
Yes, in merit is discussed and I will file a counter on that issue.
Okay. Counter. Yes. The pure question of law.
Yes, ma'am.
There are admitted dates.
Yes.
Then what is the law? He says that he received the order and your authority also says 12/4. He admittedly filed the appeal on 12/7. Now the question is that the period is months plus extendable maximum period of 1 month. So now they say that it falls on 11/7, not on 12/7. It's completely no, it will fall on 12/7. So that's a law point. So what the counter?
12/1. 12/1 of limitation. I have relied on that in my that's my first day has to be. Yes, well, last day, there's no exclusion for the last day. First day is to be excluded. So first day excluded. So if first day gets excluded, it starts from 13th.
No, that is very clear. 1999, we go to there. 1970, we got the government. Was also of the receiving room.
Yes, yes.
So that is the spirit of the section itself. So according to if we see not 12/4, then the limitation would start from 13/4, taking as a first day.
Month.
And then the 2 months has to be calculated, and the extended 1 month has to be calculated. So from whatever angle you look at, if it is a anniversary of a month, you have anniversary that's exclusive. Then also it comes within the purview. If it is not, then in that event also, by virtue of section 12, it will come.
Yes, that's my case.
Both the way.
I'm deeply grateful. That's my case.
Your Lordship, on that day I have considered by cognized. Your Lordship, Honorable Patna High Court has decided how to calculate the calendar month, Your Lordship. And on that day I have considered by showing Your Lordship that judgment. Your Lordship, Honorable Patna High Court. So calendar month means wherever it is 31 days, 31 days, wherever it is 30 days, 30 days. Your Lordship. Your Lordship. And the last day is to be excluded, the first day, on the day of
the order is served in the month of January, what will happen?
Your Lordship.
First period is to be counted because the February is 28.
Your Lordship.
28 days.
So 31 and 28.
Has to be counted in that way.
We are not counting days, we are counting months.
Months.
As per general concept, is the month plus calendar month.
Your Lordship.
Yes.
So the first day,
That is to be excluded.
that is to be
Excluded, Your Lordship.
Counted from the very next day, it will complete on the previous day of that day.
Your Lordship.
No, it will start from a, if we gave the Gregorian calendar, which we.
Gregorian,
yes.
Gregorian
Calendar.
Then in that event, it starts from a first and aims to be the 30th or 31st or 20th or 22nd.
Right.
If it is the middle of the month, then a calendar month has to be, as we call it, the calendar month has to be considered. And for that purpose, there are two views. One is that from an anniversary to an anniversary of a month, that could be calculated. In view of section 110 of the Transfer of Property Act. If you look at section 110, computation is to be done in this way.
Whereas,
You got the, you got transfer of property Act.
I have decided, I was in the division.
Look at, there also the computation.
Elections, Patna. Is it I want I'll go through that evening.
Exclusion of day on which term commences, section 110.
That's a computation, that's why
Yes.
The computation. That is.
Where the time limited by a lease of immovable property is expressed as commencing from a particular day, in computing that time, such day shall be excluded. It's
and then there's
where no day of commencement is mentioned, the time so limited begins from the making of the lease.
and
Duration of lease for a year, where the time so limited is a year or a number of years, in the absence of an express agreement to the contrary, the lease shall last during the whole anniversary of the day from which such time commences. From that day to day.
there are two provisions in the act which talks about the computation. One is in relation to animal property, and this is the general one.
This is general.
So in respect of the leases also, it is considered when the starting day is not given, then from the date anniversary to anniversary, the duration is also wrong. So anniversary to anniversary.
This section 110 will not, but insofar as section 12 is concerned, it is very much applicable. And it clearly says, the day will be the day of reckoning.
There also it says.
It also says so. Section 110 is in the same spirit as section 12. Or rather the contrary, because PP Act is earlier.
You will find on that, when the lease expires, on the midnight of the earlier or on the anniversary. 12 in the midnight. Going to be changes. That should be the correct.
Yes.
It is within the period, which means, can't say within the period of limitation. I think within the period of condonation.
Yes.
Extended period.
Condonable. And Millers, I was showing page 65 of that order. May I read, Millers? Para 8.4. The appellant in the instant case, being a doctor, has earned income by providing healthcare services which is covered under serial number 2I of notification number such and such. Hence, there is no service tax liability on the part of the appellant. They also say that there is no service tax liability, but because of the delay of 1 day, my hands are tied. That, Millers, would be an empty formality in my humble submission, as your lordship may deem fit. I have made that alternative prayer, Millers, for relegating it. But Millers, here is an order of this honorable court, Millers. A similar situation happened with relation to a doctor, and your lordships have quashed the entire order itself.
Let's see, suppress that month interpretation on the last day I have argued, that is WPC number 5872/2025, Asirvad Motors. Your lordship has decided this division day. That month interpreted by cognizing that Patna High Court judgment.
5872?
5872/2025. Your Lordship, order dated 23/4/2025. I have considered by showing myself that button I could just. That one. That I let.
Because this is the order of Your Lordship's 13th of February 2025. Mr. Das, learned advocate, appears on behalf of petitioner and submits his client as a medical practitioner. He had registration granted on 2nd May 1972 by Orissa Council of Medical Registration, Bhubaneswar. He suffered issuance of 2 notices for such and such period. Proceeding under second notice was soon dropped. However, proceeding under first notice terminated in a demand. His client preferred appeal. Appeal was dismissed by order dated such and such on alleged omission to pre-deposit. He points out from page 53 that pre-deposit was made. Mr. Das submits that also impugned order in original dated such and such carries perverse finding of his client's registration certificate having period of validity from such and such date to such and such. This certificate is in respect of his client's diagnostic center. He seeks interference. Para 4. There appears to be a mistake of omission on part of the petitioner in not having disclosed his registration certificate to show he was a registered medical. Not on the book. No, let's this. Yes.
That is the difference that.
No. What my.
They would come in the pursuit of the service tax or
Precisely.
That is one. They are the you yourself read it.
Yes.
That the appellate authority itself says that you do not come. But he proceeded to dismiss the appeal on the ground of limitation.
As your lordship pleases. I was showing this to show that
you are inviting us to say this is not held by the appellate authority.
Very well. As your lordship.
But has not come forward.
Yes. I was showing this order that in similar circumstances, even if the appeal was there, it was.
I think you have not challenged this order.
Limitation.
We have seen that without come.
My profession is doctor. Please attend Supreme Court.
Where is the calculator?
That's Supreme Court, Your Lordship, was recently.
You put an end to the entire issue here and now. Where it is said, but you do not come under the purview of.
Page 65, para 8.4 and 8.5. 8.3 and 8.4. I'm sorry. 8.3 and 8.4.
What is the ground? Let us see. What is the ground? There is a ground for confidentiality.
No, not fine. That is not fine. Not fine. Because not fine.
Not fine means here.
No, not before the appellate authority also.
Then complete. There is your application for condemnation.
Because that is there at page 31, but this is the appeal, and
Where is it?
that is not there.
Then
this guy.
Then what?
But condemnation you have to pay for. Pretending you have filed beyond 2 months.
Where is the application?
Because that application is not there. They have not.
Then how the condemnation can be done?
Let's see, in any event, if that is the plus, then in that event, if I would have been given an opportunity to rectify the defect, then I would have done so.
Sir,
But I was never pointed out there was a defect.
but it's appeal.
I bow down balance.
So there is no question of subsequently
Yes.
granting you any opportunity.
Let's see, it is.
You know at the time of filing that you are filing beyond 2 months.
Yes. That's only thing. Let's if that is the view, let's I can always file an application for condonation of delay bills before the appellate authority also. Had I been given that opportunity, I would have explained it.
Why you just don't file it?
That's that is that is something. Let's I can't improve upon the facts of the case, but that is there. There is. There has to be a condonation application. Even that 30 days, why there is a delay? Yes, I have, but let's say it is not there in the appeal. Let's I can't improve upon it. You have to explain. Yes. Yes. Although it's explained in the writ petition, but I bow down to your lordship's observation means that it is not there in the appeal. I've explained it in the writ petition. As your lordship pleases.
Only on that score, that it was within the condemnable period and the period of limitation that is, which is shown is not correct. It should be within the condemnable. Now it is open to you to satisfy.
Please. Please.
I may be
Oh, my Lord, bless.
I may be pardoned.
Concern is the last proposed matter in absence of the district tribunal.
My Lord, I may be pardoned. Item number 39. The state appeal, there was some delay. But I pray let the delay be condoned and let it be listed for final confirmation. There was some delay on the part of the state in filing the appeal. Let the delay be condoned and listed for, because otherwise it is not reaching. That is.
But may I also?
Let the delay be condoned and let it be listed for. I have a good case on behalf of the respondent. So I pray let the delay be condoned and let it be decided on merit.
They will hold that.
Conditional concession we got done.
No. I
concede for.
I mean, concede for condonation of delay only.
Oh, that's a conditional one.
But may I have your lordship's kind attention, my lords, in item 34.
Delay be condoned and matter be listed.
34, my lord.
My lord, 34, my lord, may I? May I have your lordship's kind indulgence, my lords? Item 34, 34. But this is a matter which your lordships had heard for quite some time. And my lord, may I only say this, your lordships had asked the other side as to what is the deposit of...
My lord, item 34. My lord, item 34, my senior is mentioning, my lord, from Delhi. And
We are continuing, sir. We are continuing the matter tomorrow. Yes, sir. We are continuing the matter tomorrow, the whole list.
Very well, my lord.
Yes.
Come. 28.
Everything will continue tomorrow. Don't worry. From today, last matter was
26.
26. We'll start from 27 tomorrow.
Right.